Musa. I saw Richard Sky put this up on his social media. As you know, we're watching social media all through after this humongous earthquakal Supreme Court decision. And Richard Sky wrote, they can do what they want to do. That is okay. You remember Ivor Green Street in the NDC Congress of 2015. Was it 15 or 14? I think it was 14. In Kumasi and Ashanti region, we were all there. And he gave this earthquake solidarity conference to the NDC in Kumasi. And he ended up with something. He said, yo, NDC, you can do what you want to do. We too, when the ballot comes, we shall do what we want to do. I don't know why he said that back in the day. I was monitoring the room and we all laughed at it. But when I saw this from Richard Sky, I said, what do you concern Musa? What was the problem? Two things disturbed me, and I'm going to talk about them. Yeah. The first one was the Minister of Defense. And I remember President Mahama, when he swore in the ministers, he told them something. Is that Dr. Manibuama? Yes. When President Mahama swore in the ministers, he told them something. He said, I think the video is there. He said, now that you are ministers, be careful of what you say and how you say it. Recently, the almighty Johnson Asidun Ketia, addressing the comments of the Honorable Sam George, Minister for Communication, relating to the Hawakumsin issue, he said, and it's gone viral, that a minister cannot talk like that. A minister cannot talk like that. Bring back the defense minister. Minister for Defense of Ghana. Now, when you are minister, you're a member of the government and an important member of the government, according to Article 78 and 79 for deputy ministers. Now, you represent the states. You do not represent NDC as such. You can look after NDC people better, which is allowed, but your representation is for the state. So if at a press conference a question is asked that there are rumors that somebody who is reported to have scandalized the court has come to town and that he has been given some security protection and you are defense minister, what is it? Then you say, am I an immigration officer? Minister for Defense. The one who is supposed to defend the republic. The lead administrative head of the armed forces has a press conference and says, if somebody has come that the court doesn't want him to come, why not? Me, I'm not an immigration officer. And he's giggling, he's laughing, he's almost being sarcastic. I don't care, I'm not an... I believe that President Mahama must have known these things. That's why he told them at the inauguration that now that you are ministers, be careful of what you say. I don't know, somebody was telling me when we were discussing it today that when President Mahama said that, he was 100% sure that they will fall foul of it. That's why he said it smiling. He knew that this, my people, they will do it. He said, because now you're a minister. And I said, Otchere was clear. It's not that what Sam George said was wrong, because naturally, emotionally, you can understand Sam George's excitement about people who meted out some dastardly act on him getting to receive the same thing. Emotionally, everybody can understand it. But the elevation of the office of the minister means that your emotions must be controlled in the interest of the state and in the interest of the public. Dr. Manibuama may have an emotional connection to the case that Kevin Taylor was found, for which Kevin Taylor was being asked for contempt. It was a case about NCA. He was the minister for NCA. His best friend was on trial in the matter. Eventually, his best friend got off on appeal. That one too is a story. But because we are ethical and we are professional, we don't talk those stories. We don't say it. It's not important. It's beautiful that we don't want any young man in trouble. So it's whether it's NDC or NPP is not the matter. Let's have young people work. So he may also have an interest in a journalist talking about the court in a negative way, the court that convicted NCA people and was about almost convicted somebody that he knows very well. And we know how that's happened. We know. The appeal succeeded. That's how it happened. But we know. Okay, but it's unethical to talk about it. Now, because of that, it was incumbent on him as minister not to indicate any relationship, any connection with anything, and to answer a question about somebody has come that if you don't know that he has come, you don't know, But you support the view that if he has come, the law should take its course. And those who know where he is, they may well proceed and use the states to, not to tell the journalist in a, what looks like sarcasm with smile that I'm not an immigration officer. Minister for Defense. The Minister for Defense is, by the way, one of the high-profile ministers. If you look at the pegging order, President, Vice President, Chief of Staff, I think Finance is number 1. I think Defense is 2 or 3. Maybe Defense Attorney General. They are very high-profile ministers. And I was worried. When I watched the video, I said, whoa. People were sending it to me that, your man, did you? I said, yeah, I saw it. Anyway, we have 2 interviews, so let's get into the details of the matter. We have thank you, Honorable Minister for Defense, thank you. We have a small matter to discuss. It will take just 5 minutes because Team Fojo is here and the beautiful Oponkroma is here. We just want to say this from the constitutional arrangement and from democracy, that this is the Chamber of Parliament and this is the office of the executive. There's a reason why under most democracies, including Ghana's democracy, people are called upon to elect by voting the people who end up in parliament, in the legislature. People are called upon to elect by voting the man or woman who will end up as the top executive, the president. They are called upon to elect. There's a reason why we are not called upon to elect the judiciary under our democracy. In some places it happens, but in most places it doesn't. We are not called upon to elect the judiciary because the longest lasting democracies have observed that there always need to be one state institution, an arm of government, that is the bulwark of democracy. So under the Constitution, when this one expires on 6th January, and this one also expires on 6th January, it is this one that does not expire. So on the morning of the swearing in, the morning after Parliament has been dissolved, before the new Parliament comes in, the Lord Chief Justice, acting as the 4th most important person in the pegging order, maintains the position of the leader of the state. And then the Chief Justice goes to the Independence Square. Now, the reason is that there has to be some even playing field for all Ghanaians here. Everyone understands, since Marbury and Madison, that the Supreme Court, when it's making a decision, can make a decision based on political philosophy. If you go to America, it's not a secret. They'll tell you that the Republicans have the court or the Democrats have the court. Not because the Democrats elected people to the court, but because the Supreme Court judges, of 9 of them, are divided into, people know how they think. In America, because of data, by the time you become a Supreme Court, they know that you are right, left, center. Everyone knows that. So if the court is more right-wing thinkers, then on matters that go to Supreme Court on policy, on constitutionalism, they are more likely to go left or right. On every matter of policy and constitutionalism, there's always a left and right. You take free SHS to a court, but you want to say that free SHS is illegal. You will notice that the right-wing people might support you because they don't like government participating in all of those things. You will notice that the left-wing people will not support you. They will agree that it's not illegal, government must pay for it. On a matter like that, on a policy like that, everyone knows that there will be left and there will be right. 31st December to be celebrated as a holiday. There will be left and there will be right. Election petition has come. The fact shows a certain way. Those judges who are in there for the stability of the state will tell themselves that the president has already been sworn in. He has formed his government. He's 9 months into the government. Why are you going to give a ruling that we should go back and vote again? No. I'm going to be progressive. I go on. Then there's another judge who is a stickler for truth. That's their philosophy. That even if he's in power for 2 years, if the election was wrong, it's wrong. Analysts can look at the Supreme Court of 11, 10, 9 and say that this case is going this way. That's allowed. That's really allowed. But if you come below that and you come to procedure and processes, it is not permissible that processes can change because the politics of the executive or the politics of the legislature is dictating what happens here in high courts, in court of appeal. So if somebody has defamed me, or I have defamed somebody, I've sat here and said that, oh, my neighbor Ama is this, that. Or my neighbor Ama sues me. And then he sues me in defamation. Come and prove what you said. And it should be thought that within the context of politics, the high court judge would determine that MPP is in power, so he will rule for me, or that NDC is in power, so he will rule for Manebo Ama. That should never be the case. And that has happened in Ghana recently, and I'm going to show you how it happened. The other point I'll make before I show you what had happened is that The framers of the Constitution are also aware, and I'm coming to the constitutional article. Or perhaps, no, let me do the Ken Crunchy one first. Now, this is Ken Crunchy. During the election petition of 2013, he made statements that were suggested that he had scandalized the court. Ken Crunchy MDC was in power during the election so this is 2014 matter. Or 2013, during the petition, yes, NDC were in power. So Ken Crunchy was said to have made statements that are scandalous of the courts. So they hauled him before the court. His lawyer was the learned Otchere. The court made the decision that Ken Crunchy has scandalized the court, and therefore he should serve a contempt of 1 month. He was NPP, he's still NPP. NDC was in power, he was NPP. During the pendency of the trial, Akogun, Mugabe Mase, and the other guy, they also made statements that were scandalous of the court. What happened? Guess what? They were also hauled before the court and they were convicted for contempt. Keep the 3 there, I'll come to Enieboa. Because in the context of procedure and the context of the courts, there should be no favoritism as to how the court relates to this and relates to that. NDC was in power. And the 3 of them were convicted by the Supreme Court. John Mahama was president. And then they went into prison. But here's the catch again. Because the executive president, elected by a popular majority, is an important factor in the constitutional arrangement, every constitution gives the president the power to pardon people. Do you know why it does that? Because the constitutional framers fathom that the president's brother, the president's mother, the president's friends, his classmates, the relative of his cabinet, they may fall foul of the law. And if they do, a democratic arrangement does not permit the president to save them so long as they've fallen foul of the law. So if the president's brother drives a car into 30 girls and kills them, the Constitution knows that the president, even though he's president, will not be able to do anything about it because his brother will be treated by the law as it ought to be under a democracy. However, the constitutional framers don't want the presidents to be in a bad frame of mind. And whether, because you are human, whether you like it or not, if the president's brother is jailed, he will be in a bad state of mind. If the president's in a bad state of mind, it's probably bad for the whole of Ghana. If the president is not married and he has a girlfriend, and his girlfriend goes to slap somebody at a supermarket, that girlfriend of the president will be hauled before the law. And the constitutional framers are aware that this will disturb the president. However, we do not want the president to be able to interfere with it because equality before the law is a bulwark of constitutional democracy. Therefore, in almost every constitution, the president is allowed to take some people out of jail when they have been jailed. In Ghana, you will find it in Article 72. It is entitled The Prerogative of Mercy. And Google the word prerogative. What he wants to do, you do it. It's almost like a discretion. And the Constitution gives the president that power. It says the president may, acting in consultation with the Council of State, grant to a person convicted of an offense a pardon, either free or subject to lawful conditions. He can give a person a free pardon. A B, grants to a person a respite, either indefinite or for a specified period, from the execution of punishment imposed on him as an offense, or substitute a less severe form of punishment imposed on the person, or remit the whole or part of the punishment imposed on a person of a penalty or forfeiture otherwise. This is what the 1992 Constitution grants the president. So that in effect, they are telling the president that you really cannot interfere when people who are close to you have done something wrong. What you can do is that after they've convicted, we have given you Article 72. Because we also don't want the president to be sitting there and thinking, yeah, my boy is in jail. What do I do? Then he said, have you been to his house? How is he doing? Oh my goodness, what is it? They say, Mr. President, it's cabinet. Say, oh, forget about the cabinet meeting. Charlie, they've jailed my guy. What is this? Because we don't want the president to do that. And we also don't want the president to interfere in the delivery of justice. We have given him Article 72. Now, it's interesting. It's almost like a film. This Article 72 was implemented in the case of the Montier 3. Put them back. Now, Montier 3 were jailed. But they are the president's people. They are NDC people. They are Julius Debra's people. The party people know them. The party people love them. So the president was under pressure. And you remember, president's lawyer, Tony Letha, wrote a letter to the president that you cannot remove the people from prison. I interviewed President Mahama then, and he explained the reason why he did that. It made a lot of sense. Because the Constitution grants him the power to do that, so that he does not jeopardize the judicial arrangement, which is a foundation of the Republican Constitution. So, Ken Kranchi, where's Ken Kranchi? Ken Kranchi was jailed. President Mahama didn't give him any. No, this is my neighbor, please. This is not Ken Kranchi. I beg you, take it off. Ken Kranchi was jailed. President Mahama didn't give Ken Kranchi any pardon. You're MPP man, you are jailed, go and be jailed. Okay, it's fine. Go inside. So Ken Kranchi went inside. As soon as Montier 3 were jailed, the NDC people started knocking on President Mahama's door. Article 72 is there. Take our people out. And he did. You may not like it, but it was in conforming with the Republican Constitution. Then there's another matter. When, I hope you have Sir John, please, if you have Sir John, let's talk about the Sir John matter. In the same matter, in the same case, there was also Sir John, who was, and now these convictions, what happens is that when they issue a warrant, the warrant means that come to court. Apreku will be telling us that in a minute. The warrant means come to court and come and explain. In the case of Sir John, his lawyer was Ni Ayikwe Otu. Sir John went before the same court that jailed this one and Ken Kranchi. And Ni Ayikwe Otu went and said, my lord, my client is sorry. He is begging. He is a general secretary of the party. And he was speaking as a party man. My lords, please temper justice with mercy. We beg. We really beg. Justices looked at themselves, discussed it and said, okay, Sir John, go and sin no more. So that's always a possible outcome in a contempt arrest warrant. You can go to the court and then be asked to leave. It's always an outcome. It's always a possible outcome. But the other way of doing it that I couldn't say that the Supreme Court has today, that one is a problem. But anyway, let's see the judges who did the contempt for these people, and then we're wrapping up there because we have big interviews coming up. Justice Eni Yeboah was on that panel that decided that Ken Kranchi and also the Montier 3 should go to jail. The acting Chief Justice of today, Lord Justice Bafo Boni, Justice of the Supreme Court, was on the panel. When people scandalized the court, he was on the panel in that one, and he agreed that they must serve a jail term because they don't have enough reason to have scandalized the court. What does scandalize the court mean? Insult a judge, say a judge has done this, all of that. Okay. Who else was on? Justice Doche, Jones Doche. Don't we miss Justice Doche? Everyone misses Justice Doche. He's just a sweet man. Justice Jones Doche was also on the panel in that one. And then you had Justice Gabriel Poamang, who is currently the chairman of the committee listening to the Justice Tokonu petition. Justice Gabriel Poamang was on the panel then. It was a unanimous decision, by the way. And then you had Justice Yawa Pao, who was also on the panel. And it was a unanimous decision. Is that all? So there was 1, 2, 3, 4, 5. A 5-0 decision of the Supreme Court that Ken Kranchi of the MPP and Montier 3 of the NDC, both of them have scandalized the court. NDC was the president. Both of them went to jail. NDC used Article 72 to remove their people so that they didn't serve the full sentence. This morning, the quorum was led by Justice Amadou Tanko, who presided, Justice Ernest Jehu, who dissented. He felt that the warrants should not have been vacated in the manner that it was done. We are eagerly waiting for the reasons, and then we will treat Justice Jehu's dissenting opinion in some great detail. And then there was Justice Philip Bright Mensah, who decided that the warrants should be vacated. It doesn't matter because the reasons they gave. We're waiting also for their reasons. And then there was Justice Simon Subari, who also was part of the 4. I think it's finished. And this is Justice Senyor Jamefe, who was also part of it. This is what happened today, and this is our small commentary on it, that this is not the way we should build our democracy, because what has happened means that my friend Abronye will scandalize the court. He can't say anything about the Supreme Court. And then they'll issue a warrant, and then he'll come to court and say, I have a certiorari. Because today, they were citing Kennedy Japan. That, Kennedy Japan too scandalized the courts. Didn't he scandalize? And then they went and then they removed him. So Abronye will come and say, na Kennedy Japan scandalized court. Kevin Taylor scandalized, and then the confusion will start. A court will say they won't give certiorari. MPP will put people on the streets. Police will shoot at them, and then we are turning it upside down. Because these days, with power of media, gun doesn't win. Gun doesn't go anywhere. You shoot look at Togo, they are in crisis. Look at Ruto in Kenya, all over the place. Gun doesn't go anywhere. So Abronye will go and do that, and then he knows what he's doing. He is sure about what he's doing. Then they'll go and catch him and take him to a Kumasi High Court, and he'll say he won't go. He won't go. Then he'll bring certiorari to the Supreme Court, and the Chief Justice may or may not list it. I don't know. Or he lists it, and then the certiorari fails. And then the MPP say, hey, why is the certiorari failing? When this one? And then they say, today, then we are going. They are in opposition. They don't have much work to do. They are looking for something. And then they charge in Kumasi and put 1 million people on. Kill them. And let's see. And whose fault would it be? Whose fault would it be? Okay, go to Ghana neighbor and let Apreku join me. Apreku, please come. No, hold on. Apreku is here. He can come. He can just come. So, come, let's do it. We don't have much time. We run away. I like your outfit, man.
Thank you.
So you were in court this morning, very briefly. What happened?
So the court ruled. So initially, when the party, that is Kevin Taylor and his lawyer, the learned Peter Okujeto, were in court, the Attorney General's Department did not appear. No, the picture of the Supreme Court, please.
Yeah, that's the Supreme Court. He wants the Supreme Court building. Okay.
So the lawyer, the states, the Attorney General's Department, no representative came from the Attorney General's Department. In fact, Justice...
No one.
That is so. I mean, there were lawyers from the Attorney General's Department for other matters, but not specifically for this one.
So the Attorney General was not represented?
Yes. And indeed, I remember Justice Amadou Tanko insisted and said that everybody must see that indeed the Attorney General's Department was saved, and they did not appear. Indeed.
They did not appear?
Yes, there was no representative.
But they can do that? It's easy to do
that? Well, you may, but it would be best to
but
at least appear and tell the court, exactly, appear and tell the court that we have no interests opposing the motion, but not to appear. But maybe somebody was also assigned, maybe the person could not make it. And so we cannot really jump the gun and make conclusions. It would be quite unfair to them. And so the decision was handed down. We do not have the full complement of the judgment of the ruling yet in respect of this matter. But it would seem that the main arguments the court was making was that the procedure is that the courts must first make what we call a summons. The summons, as we discussed earlier, the summons is directed at the person to attend court and show why he should not be placed in custody. The argument that actually erupted after, and in fact before, which we discussed here earlier, was that the summons operates in this instance also as an arrest warrant, in the sense that the arrest warrant is to show cause why he should not be committed.
So when such a person is arrested, he's not being taken to jail. He's being taken to court.
To court to show why he should
to the same court that did the warrant.
Exactly, why he should not be thrown behind bars.
And he can make arguments.
Yes, he can make arguments. So he can beg. He can make a constitutional argument. In fact, I even believe that, that's my opinion, Kevin Taylor should have gone before Chamber 4 and
to withdraw.
Not withdraw, but even make the argument that the power of contempt, the ambit of the power of contempt, there should be an interpretative, the Supreme Court should have interpretative guidelines for the exercise of the power of contempt.
That is too broad.
It's too broad, it's too vague, so that there could be some jurisprudential discussion, and then upon that we go to the Supreme Court for a determination. But we have missed out on that opportunity because. But maybe
he was worried that if he appears before Chamber 4, Chamber 4 will say, "I don't agree with you, go to jail."
Well, that is one way to look at it. Everybody.
But
must
somebody
face
was telling me that the other way
plays.
to have gone about it was that I bring him before Chamber 4. Whilst he's standing there, his lawyer informs Chamber 4 that the certiorari application has been filed at the Supreme Court against you. Can you stay and let's hear the certiorari application?
That's
and then the application is granted, and so Chamber 4 knows that would have been. I mean, they use certain words.
The purpose of the thing is that the arrest warrant is directed at law enforcement agencies to procure someone's attendance. And so the arrest warrant in and of itself is not a process or a procedure that goes on in courts. It is directed at the police. It's more or less an order of the police.
To go and bring this guy to the court.
Exactly.
Yeah.
A summons is directed at an individual to appear. Unlike the arrest warrant that is directed at the police
to go and get him.
To procure the
But
attendance.
arrest warrants can also location a person hearing about it, show up.
Oh yes.
Okay.
If you hear there's an arrest warrant,
so if it is true that there were agencies of state who protected him away from the court, will they have committed an offense in the light of a certiorari having been issued later?
I mean, at the time it was issued, and
that they found him.
Yes. So the legal principle: if you and I litigate over land, and the court gives you judgments, and the court says that you are the winner, and therefore the land is yours, I cannot say because I disagree, I am not complying with the order of the court. Till that order is set aside, it's the law, and it is what's supposed to stand.
So those persons may, if it's true that happened, they may have questions to answer.
Exactly, but the thing is that it is the state that ensures these things are follow through. But it seems the state also did not appear in this instance for whatever reason. So we are waiting for the full reasons of the courts in respect of this issue to make a full and comprehensive analysis as to why the court ruled in this manner. But I'm sure it's an issue of maybe a view of technicality against intent or whatever. I don't think maybe the courts would have.
There's a matter that I have to bring to your attention. It's been on most of the NDC platforms. They said that Kennedy Japan. There's another article that says Kennedy Japan's own was completely different. Kennedy Japan scandalized the court by attacking a judge. A judge issued a warrant. He went to the Supreme Court on the basis that the judge did not ask him to come and defend himself. The position of Kennedy Japan's lawyers was that Kennedy Japan is a member of parliament and you know where to find him. So the judge should have issued it on parliament that produced Kennedy Japan, and they would have done so. But to go ahead without hearing him and do that, and that's the decision the Supreme Court took. So they are thinking that it's on all fours, as the lawyers say, with this one, and there's a lot of disagreement on social media.
The issue of
that in this one, there was no way to serve him. He was not going to be willing to come. So it's clearly different if you issue the arrest warrant. You know.
The issue of service, particularly for MPs, is that there is a specific way MPs are served. So for me, if somebody wants to sue me, the person can meet me, can come to my office at Adabraka and give me a sue wherever. I'll come here on my way home. But MPs, it's different. There are days they are supposed to be served. In fact, in Parliament, there are officers that can receive processes from the courts on behalf of MPs. And the rationale is that the job of Parliament is very fundamental. We were all in this country when the D levy was passed at 11:30, 12 a.m. And so the nature of Parliament is it is standing for the 4 years. There are times here.
So every minute he's in Parliament.
Every minute
he's deemed to be doing parliamentary work.
Either exactly going to or from. Even the act of parliamentarians going from place to place, you know, talking to.
It's all deemed to be part of parliamentary work.
Parliamentary work is not just sitting in the chamber and saying yeah. And so the rationale behind that can be said that there is a format, and we all know the position of the law in the NTHC case, that when the law lays down a specific process for doing something, it is that process that ought to be followed. In this instance, Kevin Taylor is not an MP. There is no specific instance for procuring his attendance. There's no specific process for procuring his attendance. In any case, the other side may also argue that in any case, it is still the same thing, that the summons must have been issued, and then upon him failing to attend courts, the arrest warrants, because the issuance of the arrest warrant also puts some, makes him a sort of pariah. People begin to say, hey, now you arrest warrants, well, sooner, there's an arrest warrant on you, and so the court should have afforded him the opportunity to attend, and then upon failing to attend, then he would, the courts could.
So those who now want to sue Kevin Taylor, and those who have sued him already and obtained judgment, is it good news for them? Is it better news for them than that he's not available?
It's not. Well, he has to be saved. He has to be saved. And if his location in Ghana cannot be found, they can attempt service 3 times. if they attempt service 3 times, they can apply for what we call substituted service, where he can be served through WhatsApp, he can be served Facebook, posting notice on the walls of the high courts, or the notice
So he
boards
pays
of the high
Facebook and
courts.
tag him.
Yeah, you can post on Facebook and tag him.
And then the
Daily
trial
graphic,
can start.
Exactly.
It will be assumed that he doesn't want to participate.
Exactly.
Then you go
so
and get
continue.
a judgment.
And then can get
whenever
judgment.
you can enforce it against him.
Exactly. You do what we call entry of judgment, where you detail the amount of money that has to be collected from him. And then you also attempt service of the entry of judgment. If still the process, you do it 3 times, you come for substituted service, it is posted, and then it can be enforced. However, if he is not in the jurisdiction, that is also there's a different procedure for instituting actions against people that are not in the jurisdiction.
But given that he's not ordinarily resident here, he may not change that. Is he now to be considered as in the jurisdiction or not?
Yeah, he's a Ghanaian citizen, and he lives. Well, I won't say he lives here, but
he has been here to seek legal process,
exactly,
legal redress.
Yes, and he attended. In fact, if those who were going after him may have suspected he would have been at the Supreme Court, they could have been hiding at the premises. So immediately he came out.
You had the conversation between me and another lawyer who said that he just got there and then the Prado took off and he'd taken the number of the Prado and he's doing something.
He should have sat on an Okada and chased the Prado.
He said he just got there and the Prado took off. He was just going to get the bailiffs to arrest the Prado that he was using so that national security will beat them up and then we can have a story.
Maybe the lawyer is a gentleman. Someone would have sat on an Okada and chased the Prado because once he leaves the court premises, how are you going to find him again? And in our jurisprudence, service is so fundamental.
Yeah.
If you have not served a process on a party, the court can say, I do not have jurisdiction to.
But here you can do substituted service.
Exactly. That's it. So, and even the substituted service, there's a threshold. You have to attempt service 3 times.
At least
and
3
show
times.
the court at least 3 times.
So that you are unable to reach him.
I'm unable to reach him. And any future attempt would
be futile, yeah.
Exactly. And then the court would give
because he would have left Prestige Link and gone back to America or gone to
I don't know if it's at #1 Prestige Link, but that is what is in there.
I hear they are doing party. They are doing party today.
Oh, thank you very much. You are victorious. You have to celebrate.
Thank you.
My life is in stages.
And Team Fojo is here.